Hey there, I'm the MadCatster. My glad to see you here. Well, SSSniperwolf has responded to her husband Evan Sausage's lawsuit, and she has filed a motion to dismiss it. And let me tell you, as an attorney, never in my career have I seen such a bizarre pleading in my whole life. I'm going to tell you all about it and what she has to say in her defense. So buckle up and let's go. So first of all, I'd like to point out I'm wearing a Sour Boys hat, and this is in appreciation to Unconventional for all of the people he sent over to the channel. We were trying to get to 20,000 just a couple of weeks ago, and now, believe it or not, we're actually pushing 30,000 subscribers. So if you haven't subscribed yet, please like and subscribe. Sybil is upstairs. She's already in bed. She's feeling okay. I don't know. She's just tired or I don't know what, but I'm here with Cedric today, and he's being very mischievous tonight, and he's getting into everything. Lay down, Cedric. First, I want to say a quick thank you to, and I'm sorry if I mispronounce your name, but I'm going to pronounce it the French way. It's Jay Ducroix, who sent me 3 cups of coffee from the Buy Me a Coffee link down below. Thank you so much for that. I really appreciate it. Now let's talk about the SSSniperwolf lawsuit. Now, if you haven't seen my second to last video when I did a whole discussion about this SSSniperwolf lawsuit where her husband, Evan Sausage is suing her because he's alleging that she has started side businesses that conflict with the SSSniperwolf channel and business that they started together, and he is trying to get her on a breach of contract. And she, of course, either had to file her answer, or before that, a defendant can file a motion to dismiss. Basically, they're saying, we're not going to answer right now because we believe that it's totally meritless, Judge, and we want you to throw the lawsuit out. Now, these types of motions to dismiss at the very beginning of a lawsuit are frequently not successful because you really have to have evidence that there's absolutely no merit to the case whatsoever, or that the evidence will not support what the plaintiff is alleging, and then you ask the court to throw it out. But like I said, most of the time, the case continues on, and there may be another motion to dismiss down the road. But if this fails, which I'm guessing it probably will, then SSSniperwolf will have to file her answer to the lawsuit. As I was saying in the beginning, this is the most bizarre motion I've ever seen. Okay, and I'm going to put up the first page here, and I think it'll jump out at you why this is so weird. Okay, when you file a motion, any kind of a motion, usually you start off with the heading. It says, whatever the motion is, in this case, motion to dismiss. And then you'll go on to say, now comes the defendant in the above captioned matter who moves the honorable court to dismiss the lawsuit. And then you go on to set out your reasons why. Oh, here's a very rare occurrence. And I'm sorry, I'm going to interrupt this just for a second because you guys never get to see. This is Antoinette. Miss Antoinette, who is very shy. She follows me around, but she does not come down here because she's not really fond of most of the cats. They don't like fight or anything, but she's just very shy. She's very small, if you can't tell. But anyway, so Antoinette is here. That's a very, very rare treat. Normally you would start out and you would have like a opening paragraph, which they're all pretty similar. And then you would go on to make your argument for why you believe there is no evidence whatsoever to support the plaintiff's case. I've never seen a motion to dismiss open like this. Now look at this. It says Evan Young, Channel Red versus Alleges. And it says motion to dismiss. And it starts out with the heading of gaslighting. Gaslighting. That word that's overused in the media nowadays. And when I saw this, I said, what the hell? And it starts out, look at this. It starts out with a word problem. Like one of those math problems you would get in grade school on a test. It says, a bat and a ball cost $1.10 in total. The bat costs $1 more than the ball. How much does the ball cost? And it says down below in the footnote, the answer's in the conclusion, but 50% of Harvard students get this question wrong. 50% of Harvard students, well, who gives a flying F? What does this have to do with why this case should be dismissed? And it goes on to say a whole bunch of crap because Basically, they're saying that intuitively, courts believe that plaintiffs have pled enough to meet the low bar to assert a cognizable legal claim when the facts are deemed true, which that is what I was saying. Usually, it just has to be the slightest chance that the plaintiff might be able to prove their case when the evidence comes out in court. And that's what they're saying here. They're saying this case, however, presents an example of where the court should disregard an intuitive and quick knee-jerk reaction. This case is somewhat unique, but the family division should be the one to hear it. So basically what they're saying is, and I honestly, between you and me, if I was a judge, I don't think any judge would really appreciate their attempt at, I don't know what, humor here or what, but, you know, dictating to the court what the court should do. And the court should just ignore what it would normally do and take Sniperwolf's word for it that this case is unique and that the family court, which is where they're basically, family court is where the divorce between the two of them is happening, that they think that the family court should handle this along with the divorce. Well, I strongly disagree with that because, yes, while the LLC might be considered a marital asset, and then if one of them wants to buy the other out, otherwise, I don't know, theoretically, they could just continue on as co-owners of the business. So, yes, while the LLC might be considered a marital asset, this is not about dividing up an asset. This is a breach of contract claim because he's saying that Sniperwolf has ignored their agreement about sharing the revenues from the brand they created and has gone off on her own to create all of these new channels where she's trying to make deals and get revenue for herself. And some of that entails, according to him, using re-uploads of Sniperwolf content from which they are both supposed to benefit. So you're going to see that throughout this, they make that argument that somehow the family court should take this. And that's why the superior court should dismiss this. I disagree. And again, all of this stuff is just my opinion. So we start off with this very unconventional allegation about gaslighting. So let's take a look here at what her argument is. And one thing I noticed was glaringly omitted from this is there is no like legal argument section where they talk about the court's normal standard for granting a motion to dismiss and what they have to prove to get that to happen. That's omitted from this, which is really weird to me because usually you always have that section in here, but they just jump right into it. And they're saying Young vindictively brought this instant action on his own behalf with vague reference to Channel Red, the LLC, throughout his complaint. Because Shailesh allowed prior action, back last year, Aaliyah, Sniperwolf, had sued Evan Sausage, whose name is Evan Young, and she ended up dismissing that case because they ended up coming to terms, and so it wasn't necessary for her to go forward. And it wasn't about financial stuff like this. It was like about control of the channel because he had locked her out. But anyways, so this is what she says. So she says that they're currently married. They're 50-50 owners of Channel Red, and he's already said that. Channel Red owns 2 lucrative YouTube channels. I believe it's 3 because it's his channel too as well. And Shailesh is the star of the channels under the globally misspelled, shame on you lawyers, recognized monikers Sniperwolf and Little Leah. So they're claiming she's the star, but apparently, according to him, and if you saw my last video, he's basically the brains and the brawn behind the channel, and she's just the face. So, okay, I guess she's the star, but she certainly isn't the driving force of Sniperwolf. And so just after filing a dissolution proceeding of the divorce, Young unilaterally, surreptitiously, and without any company authority locked Shailesh out of the channels to obtain a litigation advantage in the dissolution proceeding. So they're saying that when he admitted this in his complaint, when he locked her out of the Sniperwolf channel so that she couldn't get into it, he did that because he was trying to seek an advantage in the divorce, which is absolutely absurd. He explained, and it sounds credible to me, that because she was re-uploading content from the Sniperwolf channel, he locked her out of it to stop her from doing that because she was keeping all of the revenue earned by the new channels that were reusing this content that they both own to make money. Young's nonsensical and spiteful behavior caused significant reputational damage to the channels and threatened impending financial devastation to Channel Red and its assets. Now again, if you listen to him, she's the one who's gone off and is trying to screw him over. Okay? It says, while conceitedly similar to the instant litigation, the TRO... See, so they're trying to say that her lawsuit against him is similar to this lawsuit. It's not. It was nothing like it, okay? Hers was a temporary restraining order to get him to give her back access to the channels. This is a breach of contract claim. They have nothing to do with each other other than the fact that the same parties are involved. Following the initial filing of the TRO, the parties quickly negotiated a ceasefire because he came to his senses and understood that his unhinged behavior, it doesn't usually go over well with the judge. And I know they think that they're making a persuasive argument, but it just comes off as mean-spirited and name-calling, honestly. Basically, she allowed the TRO to be dismissed, and she got back the access, okay? And again, they're saying the remaining issues seemed best left to the family division in the dissolution proceeding. Seemed best left to, maybe in her opinion, but not objectively it wasn't. And I don't think that a breach of contract dispute belongs in family court. The instant case should be dismissed because the issues are subsumed. They throw in all these like $1 million words in here. Doesn't make you sound smarter. By the dissolution proceeding. Here, Young vaguely asserts claims on Channel Red's behalf, but his claims actually center around him, okay? This particular argument they're making that this really isn't harm to Channel Red so much as it is harm to Evan Sausage is actually not going to work in their favor, and I'll explain why in a second. It says, there's no reason why the family division cannot address the myriad of allegations, most of which are false in the dissolution proceeding. None of the causes of action asserted are meant to protect Channel Red. Instead, the claims for breach of fiduciary duty and breach of contract are simply disguised community waste claims. So they're saying that the breach of contract is basically her wasting marital assets. That's not really true, because the assets, it's not like she's using money that was already in Channel Red's bank. She's going off and cutting him out of the deal to earn money that should be going to the company, but it's just going to her. That's not the same thing. That's not wasting marital assets. And then they say Channel Red has not alleged any separate damage to it. And he is filing on behalf of himself and Channel Red. And they're saying the complaint contains Young's direct claims only. Well, sort of. He's saying that money that she's earning on the side using the Sniperwolf brand should have gone into Channel Red. And then it would have been divided up between the two of them. So, I mean, yes and no. It says many of the other claims also fail for independent reasons. Count 4, intentional interference with business expectancy is wanting because whatever interference Sausage is claiming was not wrongful. Well, it was. Shailesh, the star of the YouTube channels, can enter into whatever sponsorship deals she deems appropriate. Moreover, there's no allegation that any vendor, sponsor, supplier, business partner, or otherwise terminated or breached a deal with Channel Red. She cannot use the Sniperwolf brand, which belongs to the two of them, and use it wholly for her own benefit, okay? Unless they've come to some agreement that she can do that, okay? So, no, they're wrong. She doesn't own the channel. She doesn't own the brand, okay? So she's not free to just go off on a tangent and screw him. It's like if the president of Coca-Cola decided to go off and use the Coca-Cola name to start a side company and make money using the Coca-Cola brand, he can't do that because Coca-Cola the company owns the right to Coca-Cola, not the president. So she's not entitled, just because she's the face of Sniperwolf, to take and use the brand how she sees fit and use it to make money and just say to him, well, too bad, I'm Sniperwolf. The family division is better equipped to decide. The complaint does not distinguish between Channel Red's damages versus Young's. While Young has historically claimed that he is Sniperwolf and he is the creative force behind the channels, even though any casual YouTube search reveals that Shalesh is the star of the channels. Again, that's irrelevant. The fact that she's the face of Sniperwolf does not give her the right to just unilaterally assume ownership of that. It's a brand. It's not a person. It's a brand. Okay? So what they're saying is in order to file this complaint, Young, Sausage, needed to allege that Channel Red suffered damage independent from him because despite his tortured position, again, my God, who are these attorneys? They are not the same. So he's saying that Sausage and Channel Red are not one and the same. Well, they kind of are, even though Channel Red is incorporated as an LLC. There are only two members, which are basically the owners, and they own it equally. So there's just her and there's just him. So kind of it is him. Young didn't make any such allegations regarding Channel Red. Instead, Young defined the breach of fiduciary duty claim with respect to himself only, saying Shalesh failed to remit Young's equal share of profits, diverting profits, entering into brand deals, sponsorships, and or other contracts without consent from Young, withholding of corporate data from Young, creation of subsequent channels, despite direct objection from Young, and denying Young access to Channel Red social media accounts. So that's the thing that they neglected to say. Yes, he did lock her out of the YouTube channel, but she locked him out of the Sniperwolf social media accounts. So I'm sorry, but he's unhinged, and what is she? Suffice to say, none of these allegations relate to Channel Red's damages, simply damages to Young. Again, this is not Channel Red's claims, but instead Young's direct claims for his share of profit from such brand deals. Nothing the family division cannot handle. They keep saying this, but they don't make an argument as to why this belongs in the family division. They just keep saying, well, let the family division, Judge, you don't want to be bothered with this case. Let the family division handle it. Why? What grounds are you using to say that this should be sent over to family court to deal with, and why it doesn't rightfully belong in the Superior Court? And this is really their whole argument. It belongs in the family. Not that he doesn't have a claim, which is normally what you would argue. You would say, there's absolutely no merit to what he's saying. Judge, just dismiss it. They're saying, judge, dismiss it and let the family court figure it out. Well, then why does it belong in family court? If there's nothing, if he has no basis. Antoinette, I think she smells a treat. Yep, she does. She smells a treat. It's so funny. Here, right there, right there. I really think this is probably one of the weakest motions to dismiss I've ever seen. We're going to be wrapping this up in a second, so I'm not going to bore you with a lot of legal detail, but here's where we get to the part where I was talking about where they're saying, well, it's all him. It has nothing to do mostly with Channel Red. This is why they were saying that. No derivative claims. And trust me, I'm not going to bore you with a lot of legal minutia. I'm going to just explain briefly in lay terms what they're saying, but let me just tell you what they're saying. As argued above, Channel Red does not distinguish any of the claims it asserts against Shalesh. Simply put, consistent with Young's unreasonably high sense of his own importance. Well, if he is the brains, according to him, came up with the idea for the channel, he says, he was the one who did all the gaming, he wrote scripts for her to read, and all she did was be the face, then I don't think he has an unreasonably high sense of his own importance. I think he's integral to the Sniperwolf brand and channel. Okay, he's not just some afterthought. He's basically the driving force behind the channel. So consistent with Young's unreasonably high sense of self-importance, he wants his share and his say. But there's nothing in the complaint that alleges actual damages to Channel Red, which, again, it's not really true, because all of the money would go into Channel Red and then get divided. And now, this is where they're going to make an argument. Furthermore, Young did not comply, and they cite to a statute because he failed to make a derivative demand before instituting this action on Channel Red's behalf. And they go on to say the case. They say in that case, the court dismissed the plaintiff's derivative claims for failure to make the requisite pre-judgment demand under the statute. So essentially, just to make it simple, in an organization like an LLC, or in my work where I've seen it come up, is with a homeowners association. If one of the shareholders or part owners thinks that harm is coming to the organization, what they are supposed to do is make a demand on the board and tell them that they want action taken. Then if the board doesn't do anything, the shareholder can then file a lawsuit on behalf of the corporation with the court. So what they're saying is he should have made demand on the board, which is absurd, first of all, because there's only 2 of them. So what, he's going to make demand on her? It says that they've had a conversation about this, okay, where they talked about what was going on. He says in his lawsuit that he told her she was doing damage, blah, blah, blah. So in my view, if you want to go that way, that's one argument you can make is, well, he did make a demand and she didn't stop. So he had to bring a lawsuit, which is, if you believe what he says is true, that's correct. He didn't have any other avenues to pursue than to go to court, okay? Let me just show you now. There are exceptions, though, to having to make that demand. It says that there's an exception to direct personal action by a member. Under the special injury rule, an owner has a direct rather than derivative claim only if the owner has suffered an injury that is special and distinct from not only any injury suffered by the entity, but also any injury suffered by other owners. A special injury is established where there is a wrong suffered by plaintiff that was not suffered by all stockholders generally. So again, even if you, for argument's sake, say he didn't make a demand, there's only 2 of them, like I said. So the wrong he has suffered was not suffered by all stockholders generally, because she's the perpetrator and there's only 2 stockholders. So the injury he has suffered because of what she's doing, she did not suffer because clearly she's getting all the gain. So I think even if you were to say, oh, well, he should have made demand, which I think he could say that he did, he's the only one suffering injury. There's only 2 shareholders and he's the only one suffering injury. And they're saying that, the court should dismiss each of these claims. Now, I don't know. They may end up dismissing 1 or 2 of the claims, but I don't think they're going to dismiss the whole complaint, the whole lawsuit. They haven't made any argument about why he doesn't have a claim, really, in my opinion. They've just made all of these allegations, and basically their constant refrain was, this belongs in family court. This belongs in family court. Well, again, I disagree with that. We'll see what the judge says, but in conclusion, this is what they said, okay? And this is the answer to their gaslighting. They don't really even go on to talk about what the hell they're talking about. Why is this gaslighting? They're just like using that gaslighting as a headline because it's like the buzzword in the media these days, and somehow what they think that the judges can say and go, oh, gaslighting. Well, get rid of it then, The conclusion, the answer to that thing about how much the ball cost or whatever, the answer is 5 cents. So they're saying the bat costs $1 more than the ball. So if the ball costs 5 cents, then the bat has to cost $1.05 because that's $1 more than the 5 cents for a total of $1.10. Again, here the court should avoid fast, and they put this in italics, fast, intuitive thinking. First of all, I have yet to see a court that acts fast when making these kinds of decisions. Sometimes it can take weeks, sometimes it can take months for them to decide. So I don't think this is going to be a snap decision on the judge's part. They're really, I think, insulting the court here by insinuating the court's just going to make a rash decision, and not apply the law. Instead, this entire complaint should be dismissed and tried in the family division because Young does not allege any claims distinct to Channel Red. If the court is inclined to duplicate the family division's work, I didn't realize that this complaint that Evan Sausage filed was also a complaint for divorce. I'm confused. How is this duplicating the family division's work? They have nothing to do with a breach of contract claim. If the court's inclined to duplicate the family division's work, it should still dismiss Channel Red because Young does not allege separate actions on its behalf. And finally, many of the claims asserted are deficient for technical pleading reasons and do not survive 12b6 analysis. 12b6 being the federal procedure rule that they're basing this motion to dismiss on. It says the court should dismiss and award Shailesh her attorney's fees. Well, I seriously doubt even if they won that the court's going to give her attorney's fees because I don't think you could make an argument that this was frivolous. I think that this is a very weak argument. I think it's a very bad motion. I think it's a very structurally deficient motion and substantively deficient motion. And I don't think they're going to win. And I think this is going to go forward. So that's Aaliyah's best attempt to get this dismissed. That's my personal opinion, by the way. We'll see what the judge says. But again, I'll keep you up to date. I'm guessing this motion fails, and she will then have to file her answer, and then we can see what her argument is for why she did the things she did and why she thinks she was justified. So stay tuned. But anyways, thank you so much, you guys. Thank you for all of the new people who have come over. And you guys who have been watching me, who still have not subscribed, will you please subscribe so we can get to 30,000? And see, Sybil even finally came downstairs because she wanted to let you know she wants to get to 30,000 too. So she wants you to subscribe. And Antoinette's still here. But thank you so much to all of our Patreon patrons. We love you so much. Thank you for your support, for helping to offset the very big monthly vet bill I have for these guys, for my 13 rescue cats. Thank you to our channel members whose monthly support also goes to offset the cost of their care. Thank you to all of you who have been here supporting me all along, and welcome to all the new people. Please stick around. Please subscribe if you haven't. I've got more coming in a few days. So in the interim, love one another, take care of yourselves, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.